Hi, what's up, everybody? This is Logan Schlutz with Estate Professionals, your Colorado Front Range Realtors. I'm just going to jump into another video talking about the dates and deadlines in the Colorado contract to buy and sell. Again, we're in section 3 here, and I'm just kind of doing a quick overview of what the different deadlines mean for the buyer. And then at the very end of the series, I'm going to put together another video that tells you exactly kind of how to organize these. So this is going to be a quick video here. This is just going to talk about items 9 through 12. The first two are the Owners Association deadlines. So the association document deadline. This is a deadline for the seller to deliver all of the HOA documents to the buyer. And so let me just, if I haven't pointed this out yet, it gives you a reference portion here, and this tells you look at section 7 of the contract. So I'm not going to go through all of this. Excuse me, here we go. But here's section 7. And if you go to section 7 here, it's going to tell you in 7.3, here are all the documents that the seller is required to provide to you. Now, it's important to know that they only need to provide these things if they exist. But essentially, go back to the dates and deadlines here. And the important thing is that there's going to be a lot of documents here, like minutes. Minutes are a good opportunity for the buyer to review what has been going on in the association, and sometimes to get an idea of what's coming down the pipeline. You might also look at monthly financial statements to see what the financial integrity is of the HOA, if there's any special assessments that have been budgeted for, if there's what do you call that? If there's a if there's a reserve study that's been done, that's a really good document to look at, because it'll tell you essentially what work needs to be done in the future. So the third-party company comes in and looks at all of the things that the HOA is responsible for maintaining, and then they're going to give you a written report that says, okay, based off of the amount of work that is deferred, or the amount of work that you need to budget for in the future, and the amount of work that your HOA has in reserves, you're on target or off target. And if you're off target, this is how much you need to be raising HOA fees by, or this is the number of special assessments that you would need to implement in order to get yourself caught up. So that's a really good section to read. Other things that are important in here are like rules and regulations, just to make sure that the buyers are comfortable living with all the rules. If for any reason the buyer is not satisfied with the information that has been found within these documents, the buyer is able to cancel the contract and get their deposit back. So a lot of times I see buyers and they want to review all of this information ahead of time, like before they make their offer. And while it certainly has its merits, it's not totally necessary, because once you receive all this information, unless you've just waived this or given this right up, in almost every circumstance, there's an opportunity for you to cancel the contract if you find the rules of the HOA unacceptable, or you're unhappy with their financial situation, so on and so forth. And this is in the buyer's sole subjective discretion, so it's pretty cut and dry, the buyer's rights, that is, in terms of being able to break this contract. All right, so the next 11 and 12, seller's property disclosure deadline. So by default, the Colorado contract says the seller is going to give the buyer a seller's property disclosure. The seller is required to disclose anything that they know to be materially wrong with the property. So there's a lot more that we could say about this, but in almost every circumstance, the seller is required to provide the seller's property disclosure. And then the second one, this item 12, is a lead-based paint disclosure. So, excuse me, if the home was built before if the home was built before 1978, federal law requires that there is a federal that there's a lead-based paint disclosure that would go with um, the contract, right? And the lead disclosure is just going to have an opportunity for the seller to say, yes, we know that there is lead-based paint, um, and yes, we have reports that relate to it, or no, there's not lead-based paint, or we have no knowledge of lead-based paint, and no, we don't have any reports that go along with that. So this is pretty easy here. Every property that was built before 1978 is required to do this, even if you don't know if there's any lead-based paint. And it's just checking a couple boxes in here. All right, so that's essentially 9 through 12. And then the next time we're going to go through the new loan application deadline, new loan terms deadline, and new loan availability deadline. Generally speaking, items 16 through 21 are going to be things that we don't see very often in a standard contract, so I'm going to skip these. Of course, if you're doing a cash offer, you're not going to need these items, but I am going to go over them in the next video. So hope to see you then. As always, if you have any questions about Colorado real estate, or you need help getting connected with a realtor anywhere across the country, please reach out to us. We're more than happy to help anytime. Thanks so much, and we'll talk to you guys soon.